Sure.
All right, and we're going live now.
All right, thank you very much. We're back in the Judiciary Committee and continuing testimony on H230. And we have from the Defender General's Office, Rebecca Turner. Thank you for joining us.
Hello, thank you for having me. I was telling somehow on the break that you may not have remembered me. I was here at the beginning of the session to give an orientation, but I have not been back since to testify. So my first time back. For the record, Rebecca Turner from the Defender General's Office. Here to talk about H230, and actually it was nice to hear Rory Tebow testify before. And for those who have heard me testify on other bills, it is not often that I can say that many of the positions that Rory Tebow expressed here in terms of concerns about H230, we share as well. And so I appreciate him sharing those, and I will build upon some of them, but also want to highlight the fact that the state's attorneys and defense counsels.
I just can't resist. Did we have a bonding party over break here or something?
I know. Well, I'll tell you.
We share chocolates. I mean, what happened?
So let me share this because I know time is short and you have other witnesses and you have a lot to go through. This is a big bill. You've heard that from other witnesses. I want you to hear it from me. It's a big bill in terms of the complexity of what you're trying to address, but from where I'm going to speak to you from primarily as a head of the appellate division, where I'm reviewing these laws in a litigation sense and looking at it from the constitutional side of the side. I find this bill enormously complex to unpackage, and there are several concerns that I have with it on its face. And so on behalf of the Office of Defender General, our position is, right out the gate, we oppose this bill in its entirety, all of the sections. I'll focus, I think, where there's interest here in this committee. I can start there first, but I find that the bill is unconstitutional multiple times over. So you have heard witnesses talk about the Second Amendment issues. You've heard Rory Tebow talk about the vagueness concerns raising due process problems. I have a few more to add to the mix, but I also join in the others already expressed. There are questions earlier about, well, what is our role here in terms of how deep do we go in terms of understanding and fixing these concerns? I think that as the chair expressed, there's a duty to make sure that any law that is passed is actually legal. I would think by lawmakers in this state. I certainly would hope so. And so my testimony here today is to focus on sharing why I think this law under the Second Amendment is presumptively unconstitutional. So you're starting at the opposite place. And for those of you who are new to the legislature, welcome. What long time lawyers are trying to get their head around with the Bruin decision is it flipped the legal analysis and approach to constitutional review of statutes generally. Now, generally, we start from a premise of statute is constitutionally sound. Bruin set forth a different test. You've heard that. I've heard the explanations you've heard. If the conduct you're trying to legislate falls within the plain text of the Second Amendment, then it is presumptively unconstitutional, period. So if the conduct being regulated in Section 3 or the waiting period section is on its face capturing conduct protected by the Second Amendment, you have an unconstitutional statute. So I want that to sit, because what that means is you will pass a presumptively unconstitutional statute, and now that is just ripe for when there's the right litigant to challenge it. And who has the burden to prove it is not unconstitutional after Bruin? We know that is the state. The state has the burden, and the state has the burden to show that there is a historical tradition of regulating that kind of law. And so the historical tradition analysis that you talked, people have shared that prong 3, prong 4. Keeping it simple, the state has the burden to show that there is a historical analog, similar both in how the regulation burdens the Second Amendment and why it burdens it. And so, yes.
Just a question. Were you in the room for Billy Clark's testimony?
Yes.
Billy Clark had a different characterization than you're giving us right now. He said that basically you define the course of conduct, see if the plain text of the Second Amendment permits or does not permit that course of conduct, and then if the plain reading does not permit that course of conduct, we then turn to historical analysis. And you just gave us a different characterization of the Supreme Court, where you said that we're starting from a place of presumptively unconstitutional, and then moving to the historical analysis text. So if you just sort of explain,
Yes.
either I wasn't understanding both of you well, or if you could explain why you interpret it.
No, that's fair. It is complicated. It's here. Let me try to. We're sharing the same. We're on the same page on this point. The conduct being regulated here, the keeping of firearms, right? The keeping of firearms, how to keep the firearms, how to store your firearms or keep, that's the language in your bill, right? And the question is, does that conduct fall within the text of the Second Amendment? So identify the conduct being regulated, does it fall within the plain text? If you find that it does, then it is protected conduct, protected activity on the Second Amendment, and so any regulation that infringes upon that is presumptively unconstitutional. So what was left out there was this presumptively unconstitutional position that is clearly set forth in Bruin, and it's critical to understand because then it's about who has the burden and what is the legal status of it. And so that is, I'm jumping right to the Second Amendment, but I didn't mean to go there. I want to be responsive to your interests and questions. I know you've heard a lot already on this bill, but I can start anyway. Would you like me to focus on the Second Amendment part, or? Okay, so actually, I'm trying to change. So I didn't hear an overwhelming yes, so I'm actually going to change that up. I'm going to go to something that Rory Thibault started with, and I would like to expand upon. In Section 3, there was discussion about the mens rea. Rory talked about this offense as effectively being a strict liability offense, meaning that there is no required mens rea or intent to do any criminal wrongdoing. And that is what this statute has created. I agree with him on that. And that's because in line 18, is that it? Yes, 1819. If the person knows or reasonably should know, it's the reasonably should know language that creates a strict liability. That means that you don't have to know, you should have known, right? So a fundamental principle in criminal law is that there has to be a mens rea, that there has to be a knowing, culpable, criminal, guilty mind to warrant the punishment. Now, as the case law in the U.S. Supreme Court has set forth, there are some instances when the legislature can impose and create those kinds of strict liability laws, right? The Supreme Courts, the courts of review will look at whether or not this is one of these instances. They look at what is the punishment attending it. Here you have punishment attending as high as felony of 5 years. Now you're in dangerous territory in terms of a due process violation. There's a separate problem under due process that Rory didn't talk about, and it's separate from the issue of creating a strict liability offense. And that is as a lawmaking body, as a legislature, you have incredible powers, police powers, to create crimes out of anything. But there are limits on those powers, even though they're extraordinary, there are limits. And there are limits, and we know this because of the United States Supreme Court found so and finds it a due process violation when the legislature criminalizes conduct that is both without a mens rea and criminalizes conduct that is inherently innocent And now in your particularly dangerous waters, passive conduct. And this statute presents all three. You have no mens rea, you have innocent conduct that's actually protected by the Second Amendment. It's just keeping arms, right? And you're now criminalizing the failure to store it in the right place unless you're keeping it on your body in control, right? And then passive conduct, so you don't have to do anything. Now the U.S. Supreme Court has held that is a due process exceeding the legislature's policing power. So it's a separate due process problem. Washington Supreme Court 2 years ago in a decision, do I have that here? Blake struck down a felony drug possession statute on those grounds. And it rocks the world out there. And I see this bill as absolutely stepping on that in that territory.
Okay.
Thank you for this perspective, because I, again, am appreciating trying to understand the constitutionality of this. And at the same time, I feel like we're hearing overwhelming testimony that passing these are going to protect people in Vermont and save lives. And so I'm trying to balance with, like, yes, like I want to make sure it is at least somewhat constitutional so that we can move it forward. That I'm like, even if it passes in 2 years from now, it's found unconstitutional. If it saved lives, I'm going to feel okay with that. And so my understanding with this is that this language is similar to what's in other states, and it hasn't been struck down like the day after it passes. Is that correct? Or like, what is the process we're talking about if it is found unconstitutional? I feel like it could be years before, and in the meantime, lives could be saved.
So the question as the policy question you're asking, which is, will this have an effect that is desired, is to me a critical question. But that's, as policymakers, that's not what an answer. That's not something I can answer. Although I will point out that in preparing for this testimony today, this is getting to the IRPA side of this section, the extreme risk protective orders. There is in current legislation a reporting requirement in section 4062, 134062, and a report should have been issued, was due the first one, September 1, 2022. I looked for this report to the legislature. It should have come from the court administrator and assistance from the Agency of Human Services. In that report, they were supposed to provide an analysis of the impact of the IRPAs on suicide rates, including any relevant data that could help. Now, I tried to look for this report because I thought it would inform the policy questions, assuming there is a connection. District of Columbia v. Heller, you have heard about. There aren't many U.S. Supreme Court decisions. Heller and Bruin are doozies. They are, every time I read those decisions, I learn something new. You going in and dropping in on a section to read as part of it is illuminating. They were not decisions light. Justice Scalia wrote Heller and explained extensively how to go about the historical originalist analysis that you asked earlier, and addressed your concern in terms of, well, if this can have an effect on saving lives, why not do it? And you can read the U.S. Supreme Court majority opinion in Heller at the very end of that paragraph, poignantly says that it's not that this is the only option. Is it the other option? It just means that certain ways of trying to achieve a policy goal are off the table because of the federal Constitution. And that's what Heller was trying to explain. Now, again, I'm not the expert in the policymakers. Are there alternatives out there? Right? I was speaking with others and trying to look at to what extent is there adolescent mental health services being provided in the states, for instance, having a direct effect? I don't know. But it seems to me a much more of a direct connection to what the goals are to be achieved here in terms of avoiding suicide rates than going about this very indirect way of questionable and certainly from my perspective, unconstitutional position. But let me go back so that's the due process, strict liability, police powers concern.
I just want to add, I think we heard from Dr. Bell that that's not the case, that there isn't the direct correlation that you'd think that you would see as far as mental health interventions and reduction in suicide numbers in Vermont. Pretty sure we heard that today.
Joe?
That's a quick process question. If a law such as this one was to be challenged, would there be typically an injunction against its enforcement during the period of its challenge or not?
Well, I think typical is the question. I mean, we just lived through New York, that litigation someone was talking about earlier, an attempt to get an injunction was they lost that in that instance. What is the process? Someone asked it timing. I mean, there has to be, if there's going to be a challenge specifically, there has to be a litigant. There has to be, if it's the case of a new crime, a prosecution. And then there has to be the specific challenges, and then it has to work through the courts and experts hired. There's a New York Times article today about how Bruin has led to this entire litigation. You heard someone talk about over 200 cases, lost track of it. Well, and then there's the experts being hired and the historians for several $100s an hour each to talk about this and debate it all out. Once that works out, you go to the appellate court of review and on and on and on.
So can I ask a quick question before, unless you're still answering that question? Yeah, just what's the case citation for the case that related to no mens rea passive conduct?
Yes. So existence of mens rea is the rule rather than the exception. Staples, the United States, 1994. The prohibition against criminalizing essentially innocent activity and particularly wholly passive conduct. That's Lambert v. California, 1957.
Do you happen to have the citation?
I'll email it. I'll send that to you, and I'll CC Eric.
Yeah, sure.
Patrick. And then just generally that it's the due process clause that limits the legislature's police powers in this area. That's Nebbia v. New York, 1934. So vagueness problems, due process, police powers, overbreadth problems. Overbreadth now this is where you get into the Second Amendment, because this is now regulating protective constitutional conduct. And I will, focusing on Section 3, share my thoughts on what conduct is in fact being regulated here. I think it is absolutely an easy one. This falls within the plain text of the Second Amendment. This is concerning the keeping of firearms. Firearms is defined here in that statute cited here. I was looking up the definition. It's 13 VSA 4017D. Should take a look at that definition if there's any question as to whether or not the firearms reference here could be firearms meant. I mean, it is an incredibly expansive. I'm looking up the firearms definition here. It's firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. That's a firearm. I think you get this into the plain text. It regulates the keeping of firearms. So now that you're in the plain text territory, you're in a presumptive unconstitutional territory. So then the question becomes, and it is good to see that this committee is hearing from witnesses whether or not there are relevantly analogous historical laws establishing and satisfying that Bruin test. So it's not just that there are relevantly similar historical laws regulating the same, there has to be a tradition. And so the US Supreme Court made clear that a tradition means not just an outlier here or there, right, but truly a tradition. And when is also critical. It's not any time. There was reference to some Vermont statutes on the books. Rutland, I heard, I think it was Montpelier reference. I think I heard dates of 1880. I was able to print and download one from 1863 relating to gunpowder things, right? So when is relevant? It's not any historical laws. The US Supreme Court said 1791. And 1791 isn't plucked out of the air. That is the date that was the year that the Second Amendment was ratified. The open question you heard about is whether it can also include 1868, the period up to 1868, which is when the 14th Amendment was adopted. And so therefore the state's theory made another decision to recognize the Second Amendment. That's an open question. We know 1791 is it. let me speak to, and because you got a flavor of the complexities of doing those historical analogies of those laws. That's what's happening at the trial court level and the experts you need to look at. The historical law that was talked about here was a Vermont-specific gunpowder laws. Now, you've heard a lot about Bruin and the test, but you haven't heard a lot about what I think is the controlling U.S. Supreme Court decision on this statute that is unconstitutional under the Second Amendment. And that is District of Columbia v. Heller. District of Columbia v. Heller overturned a D.C. law, finding that it was violation of the Second Amendment, and that D.C. law concerned and regulated the, I'm pulling it here, this is the first sentence of the decision. We consider whether District of Columbia prohibition on the possession of usable handguns in the home violates Second Amendment. Usable handguns is the phrase used by Justice Scalia there because in that law, they required the ammunition to be stored in one place or another. You heard a witness earlier testify that the U.S. Supreme Court has already ruled that these sort of effectively rendering a firearm unusable, similar in a way that this is being proposed here, is unconstitutional. This majority of the Supreme Court got there by looking at historical laws. They looked at whether or not there were historically analogous laws to sort of essentially rendering your firearm not usable at the time of the beginning. And those gunpowder regulations were brought up, not the Vermont one specifically, but Justice Breyer, who comes out in dissent, talks about the gunpowder regulations in effect at the time, and the majority addressed them. And what the majority addressed and how the majority, some dismisses these gunpowder historical laws, informs how we do this and think, and why the justices said thought it was not the same was they saw these gunpowder laws as targeting excessive possession of gunpowder, not all possession of gunpowder. This would render unusable all firearms, right? Under the certain circumstances. The gunpowder analogies and the one that was raised here, and I saw the law there, it was in excess of 1 pound of gunpowder or 50 pounds. There was also another part that he didn't include in the reading. Again, that's an excessive gunpowder, not all gunpowder. Again, you've got to distinctly, like that's not analogous anymore. So that's out. The date of that law, 1863, again, post-date 1791. That's now not relevant. So under the Bruin analysis, there has not been a showing yet that I have heard that there exists a historical tradition regulating this similar conduct. As led.
So is it just, I wanted to ask for clarification, is it in 4024, is it the separate from ammunition and in a locked container or equipped with tamper-resistant mechanical lock? Is it the combination of those two pieces that you find unconstitutional?
It's the effect that you render your firearm unusable for an entirely constitutionally legitimate purpose, for self-defense. And that's what Heller found. You cannot require and punish someone for having a firearm, then you can't use it for what is protected activity. So yes.
So would it still strike you as unconstitutional if the requirement to separate the ammunition was not there?
No, I mean it's separating the ammunition. It's the locked. Here it was a trigger lock. The issue to render the firearm unusable wasn't about storing the ammunition somewhere else. It was just a trigger lock on the firearm itself. Okay. So that was found to have crossed the line and was unconstitutional.
I'm just looking at the American Bar Association. This is from 2020, but they say at the same time, Heller made clear that the Second Amendment is not unlimited. Under this framework, DC's law was unconstitutional because they're completely inoperable. But in contrast, courts across the country have routinely found that safe storage laws that require practices such as keeping firearms in locked containers or using trigger locks do not infringe on self-defense rights.
And that, I don't question that reading. The issue now is Bruin came down last June. And Bruin changed and created a whole new analytical framework to this, rendering all of these decisions effectively overruled. right? You cannot rely on
You
them.
just said that Heller was still the guidepost.
Heller is the guidepost in terms of my guess is looking at these other decisions that upheld the Safe Storage Act, they got through to the second stage, which was the means ends scrutiny, which is balancing the government's interest and purpose to the burden, right? That's the test that's now no longer in existence after Bruin. If those decisions rested on that part of the test, which I suspect they did, then those are no longer valid cases, right? We cannot rely on those as precedent, controlling, or guiding us in the future. Any questions so far? Okay, keep going. Okay. So I think that is on the Second Amendment in terms of, I just don't see a way to save that. I'd like to talk a little bit about the vagueness a little more deeply, due process. You've heard already Rory talk about specific phrases in there, custody or control, lines 18, 19, what does that mean? I have concerns on page 3 on line 2, what's an authorized user? On line 6, there's lawfully authorized user. Sorry, I think your page number. Say that again? Line 3, page 3.
Yeah,
I see. Authorized user, and then line 6, you have lawful author. I don't know what an authorized user or a lawfully authorized user is. I don't know. It's not clear what line 5 under the control means. When you have a statute that has not just one, but entirely riddled with vague and undefined terms, the U.S. Supreme Court has found that fails to meet fundamental due process notice requirements, because you cannot know what conduct will subject you to up to a felony, right? I mean, that is at risk of challenge, and I think cannot pass notice requirements. Moving to the penalty side, Rory talked about the inherently vague term threatening on line 15 on the same page, and that is a fair statement. I have been involved in a lot of litigation on the term threatening throughout Title 13 and what its meaning. The due process requirement against vague crimes extends to vague sentencing language as well. So if there's any question, that's there. But the other issue on your 10 penalties section is that the 1, 2, 3, 2, and 3 have additional facts that, if found, will warrant the misdemeanor increase or warrant the felony increase. Now you're into yet another constitutional violation territory, and that's the Sixth Amendment. The Sixth Amendment guarantees the right to a jury trial, and that includes the right for a jury to find beyond a reasonable doubt all relevant essential facts subjecting someone to incarceration to a penalty. Here, how this is written, you've pulled out these critical facts out of the essential elements of the offense itself, which would be in section A1, right, on those 2 pages, turned it into the penalty section, and now have removed the fundamental right to a jury to try those, to have you have a jury of your peers find these aggravating facts, subjecting you to substantially more time in jail. So that is a fundamental problem there, and that's a separate Sixth Amendment right to a jury trial.
Say that again, because I'm not following you there.
Sure.
So we have the definition, which is page 2, lines 17 through 20, basically. A person shall not store or keep a firearm within a premises that are under the person's custody or control. If the person knows or reasonably should know a child or prohibited person is likely to gain access to the firearm unless the person stores or keeps the firearm separate from ammunition and locked container. And then we go down to the penalties. So you have the $100 fine, and then it steps up to $1,000 if a child or prohibited person gains access to the firearm and uses it and then steps up to an even higher level if the child or prohibited person gains access and uses it to cause death or injury. So I'm wondering.
So what's the difference? Sorry.
Yeah, because, in the initial definition in 4024A1, it only talks about the idea of getting the firearm. And then in B2 and 3, it then adds additional elements of gain access and use in commission of crime or threatening, or in the highest level, gains access and uses it to cause death or injury. So aren't those just higher? What's the Sixth Amendment issue there? I guess.
Right. So the whether or not is this something that, as written, at the sentencing phase after trial, does the state just have to meet what type of burden to show this aggravating fact to warrant this type of penalty? Right, that's the question, because it's written in the penalty section, not in the essential elements section of the offense that's being proposed. So what facts are required to be found by jury beyond a reasonable doubt? What facts are required to be proven by the state beyond a reasonable doubt? And is there a right of the defendant to have those required findings found by a jury?
So just to restate that, because I think I'm understanding what you're saying here, we could have three separate crimes, one which is as defined on A1, and then we could have another one that's exactly what it says on A1 and then has all this additional stuff. And then same thing. So this could be three different crimes. What you're pointing out here is we have one crime that then gets enhanced in some way by additional facts. And because it's in the penalty section of the statute, therefore, it is considered facts to be found during the penalty phase rather than facts to be found during the trial phase.
Yes.
And of course, penalty phase is done by the judge typically, right?
Yes.
I'm not a criminal attorney.
Yes.
That's interesting. Is there any other type of law? I'm just thinking we have like first degree manslaughter, second degree manslaughter, and things like that. Are there any other laws that do this sort of thing that we have going on here?
If it's Apprendi is the U.S. Supreme Court decision requiring. So the question you can none is coming to mind.
Okay. Yeah.
But the way it's written here is not consistent with the Sixth Amendment on those concerns.
Great. Thank you. That's helpful.
Okay, so that is, I think, I think summarizes Section 3 concerns. Moving to Section 4, I also want to echo Rory's previous concerns about expanding this section to include family members, starting from the premise of appreciating how expansive household members is currently defined. You've already heard that includes a definition of sweeping nature, capturing all previous people you've dated in the past. And there's no limiting piece of it. The way that this language is setting forth in lines 14, 15 about who can petition any family or household member. So there's no limiting aspect to that, not only as to who could conceivably fall within the meaning of family, but where that family or household member is living. So does this mean that someone who's residing in California, can they file a petition? I understand, I heard the discussion about jurisdiction and venue transfer. I am not, in terms of how this satisfies jurisdictional laws, and whether that's inconsistent with current laws. It just raised a lot of questions for me that I haven't had a chance to run down, but that was another lot of red flags there. So yes, the extraordinarily expansive expansion of this proposal here by adding family or household member to it. And again, just returning to section 4062, which is not here being proposed to be changed, it's just that there was a reporting requirement. And the report should have been issued just a few months ago as to how useful this entire relatively new set of statutes, how it's been. And I certainly was looking and couldn't find, and I'm curious to know what that report says. It would certainly inform me to better respond to it, but we had concerns before when this was initially proposed, and this to me is a proposal to expand, and it seems to be a proposal to expand in the dark. Like, for what reasons? Again, I would think that the committee would want to hear and read and understand that report before we start diving back into the statutes and trying to make fixes that may not in fact be a problem, or there may be other problems that you're ignoring. And I think that that is it for now, unless there are any specific questions.
Other questions? Echo.
Okay, thank you.
I had this question earlier and I wasn't sure if I might have missed. I think when you were saying that one of the sections is violates the Second Amendment on its face because the Second Amendment protects the right to bear arms, to keep firearm. And it occurred to me when you said that with it referring to the waiting period, that's
Thank you.
The right to acquire a firearm. So I wondered if you had the same issue with that section.
Right. No, thank you for that. Whether or not transferring a firearm to another person, transferring inherently involves possession, right? And so it's about passing along or possessing or keeping. I think that this falls within the plain text of the Second Amendment. So I do, and thank you for I forgot about Section 9. There's so much to this bill. So again, on its face, I think that this is regulating conduct falling within the plain text of the Second Amendment, therefore rendering this section presumptively unconstitutional. So then the next part becomes, is there a historical analog, a relevantly similar analog establishing a historical tradition from 1791? And I haven't heard testimony on that question. And I think then if you know that this is presumptively unconstitutional, then as lawmakers, that is what Bruin has taught us to make sure that a law doesn't violate the Second Amendment. Then there has to be a showing. There has to be a look, some indicator of historical laws. Again, not just any history, not just any laws. The relevance is looked at the how and the why, how the law burdens the conduct be at issue and why the law burdens, and are those two pieces of it analogous to this conduct?
So are background checks constitutional?
So I would, again, I think this is presumptively background checks. This is not regulating background checks. It's creating a new crime for transferring a firearm. So that's a different question. I'm sorry, I didn't.
So where I'm going with that is, I wonder if the fact that background checks have been found to be constitutional, that seems like an example of a regulation on the acquisition of firearms. So why would this not count as a similar regulation?
So each law that infringes upon conduct that is protected by the Second Amendment, you have to ask for that particular activity. You have to go through that same Bruin analysis, right? So here, again, if it was previously upheld, the question becomes under what basis, what an analytical test was applied? Was it the Bruin test or not? Anything pre-Bruin is suspect, right? So now the question is, are there historically relevant analogous laws to this issue, which is 4 and 5? And you're right, and then 6, so is there something that is closely similar to the requirement of background checks 1791? You heard testimony that, an identical twin isn't required, and that Bruin made that clear. But Bruin also set forth a very detailed test as to how to do the question as to whether a historical law is analogous. And so I think there has been some muddying of the waters by other people who've been testifying as to how to do that analysis. It is actually very clear in Bruin how to do it. We just have to now do it every time there's a law at issue.
Okay.
Okay, thank you.
Karen has a question, so.
Ask a question, because I think, I'm kind of gonna just keep going with this point of it. Because I agree, like, the concept, it's up in the air, depends who you talk to and what you hear. And so I appreciate hearing another perspective of it. And I think the piece that's hard for me is like negating the other side. Because I feel like we're all at a place where we're saying things need to be tested more. It's going to need to go to court. And so I'm trying to understand, like if you had a client or somebody that, there's different perspectives out there, probably be like, okay, yeah, it's going to have to go before a judge to be seen and be determined. And so I'm just hearing from other sides that they're like, yep, we're going to have to just prepare for an argument. But I'm hearing more from your perspective of like, it's just clear. There's no gray area, no room to have a discussion before a judge to determine this. It's already set.
So I think Heller, District of Columbia v. Heller, is extraordinarily close to the conduct reviewed there and the conduct here being regulated. And I would hope that this committee reconciles Heller and the law that was at issue there and how the Supreme Court analyzed that law and found it unconstitutional with the new Bruin test, which is now being more specific at how to find the historically relevant law. But I would certainly question, I think we absolutely don't have an appellate court reviewing this precise law, but if there were another court out there, appellate court, not controlling in Vermont, not the United States Supreme Court, then it is, I suppose, technically an open question, but as lawyers and how you talk and think about a case, and I think about a case like I'm talking with you, I have an obligation to understand constitutional law and duty to uphold the Constitution. I am sharing with you my views of it and what the current test is and what is clear. Absolutely, there's a lot of unknown, but the test is clear, not just by a plurality of the United States Supreme Court, by the majority. And while people may disagree for various reasons, the impact, the effect, or whether it's sound, it is still our final court, our highest court of the land, interpreting the federal Constitution. There's discussion about the Vermont Constitution. I was involved in that Mish litigation. I represent Mr. Mish and was involved in that specific case. Absolutely, this committee should be concerned with the Vermont Constitution. It's a separate, independent source of law. But here, the Second Amendment, I think, is more protective after this Vermont Supreme Court's interpretation of Article 16, and therefore, while you can go through the analysis of the Vermont Constitution, you still have to make sure that the law is constitutional under the federal. And I think here the Second Amendment and Bruin and Heller answer that question that no, this is not constitutional. Thank you.
No, I really appreciate it. So, we have one more witness, but we have our counsel is legislative counsel, and we have heard from him, and we'll hear from him again. But what I've wanted to do, and Rebecca was great that she came here and did this, and other folks as well, is hear the arguments on both sides. Rebecca would be the person, if such a case was brought in Vermont, would be arguing in front of our Supreme Court. So I have nobody better who can come in and present that argument. Whether I agree with it or not is a separate issue, but it's, you know, so that's kind of what we're doing to really hear what those arguments are. I think ultimately who I then ultimately refer to as our legislative counsel. And I ultimately also say that, well, I'm not sure if it's constitutional or not, so I'm not going to do it. That's not the approach I would take on something that's such important public policy. It's like, there are good arguments for why this is constitutional. There are good arguments why or not. Our legislative counsel says, yeah, we don't know right now. Well, it seems important enough for us to put this forward. That's kind of where I am kind of. But anyway, but it's really good to understand the arguments. And I think there's a lot of legitimate positions that we've heard that we're going to have to do a little tweaking on this bill to make it better. So with that, we're trying, I don't think we're going to get to Judge Zone. Still possible, Judge Zone, but if you're still around, that is. And we'll see if we can get to you still, but I think we have to be done at 4:45. Is that going to work for folks? So we might be able to get to you. So, but we're going to start with Allison because Allison's not available after today. And I do understand Judge Zone is. So, Allison, over to you. If you could identify yourself for the record and proceed.
Sure, thanks everyone. Afternoon. My name is Allison Shee, and I serve as counsel at Everytown for Gun Safety, where I'm responsible for supporting state legislative efforts in Vermont. I want to thank you again for the opportunity to testify in support of H230. So I've previously testified on the evidence that the provisions of this bill are effective for suicide prevention and how the provisions of this bill have been well drafted to withstand constitutional challenges under Bruin. Today, I want to provide some further detail on some of the questions that have since been raised in committee hearings before today and also today. I understand first that there is a curiosity about how the firearm storage provisions of H230 compare with those of other states that have these laws, and specifically how the penalty structure compares. So as I laid out in my previous testimony, there are 23 states and DC that have some form of firearm storage law. So it's 24 laws around the country, including every other state in New England. 9 states and DC have laws that provide penalties for failing to store a firearm securely, regardless of whether a child or a prohibited person actually gains access to the firearm. Nearly all of those jurisdictions, like 9 out of 10 of the 10 of them, provide for criminal penalties when a person fails to store a firearm securely, even when no unauthorized user has access to the firearm and when no harm has occurred. 14 states have laws that only assess penalties if a child or a prohibited person actually gains access to or causes harm with an unsecurely stored firearm. All of those states, with the exception of New Hampshire, provide for criminal rather than civil penalties in those instances. The penalty in Oregon's law is more akin to H230 because it contains only a civil fine penalty for instances when a person fails to store a gun securely and no unauthorized person has actually gained access to the firearm. We feel that H230 would give Vermont one of the most thoughtfully drafted laws in the country, as it will establish a proactive responsibility for gun owners to lock up their firearms around children and people who are legally prohibited from owning guns, but is careful in so doing to not overly penalize gun owners for minor violations. H230 wisely provides for graduated penalties and ensures that unless unauthorized access or harm occurs, violations are only punishable by a modest $100 fine. So this will help to reinforce that responsible gun ownership is a core value in Vermont without overly imposing criminal penalties on gun owners who fail to secure their firearms, unless and until those unsecured weapons are actually accessed by children or a person prohibited from possessing a firearm or are used to do. I also want to address some of the misinformation concerning the constitutionality of firearm storage laws. The Supreme Court in the United States, case of the United States District of Columbia versus Heller, did not invalidate firearm storage laws, as the decision itself made clear. And since it came up, I want to quote from the decision, nor does our analysis suggest the invalidity of laws regulating the storage of firearms to prevent accidents. So instead, Heller invalidated a law that, as the Supreme Court interpreted it, required people to keep guns unloaded, even if under attack in their homes, which is not what the bill you're considering would do, and not what any of the other states' existing firearm storage laws do. Instead, courts considering secure storage laws subsequently after Heller have upheld these laws, including the Ninth Circuit Court of Appeals in Jackson versus the City of San Francisco. All 24 storage laws across the country remain in effect and enforceable today. None have been struck down as unconstitutional based on the holding in Heller. Secondly, I want to assuage any concerns that enacting a waiting period law without an exception for gun shows would functionally prohibit the operation of gun shows in Vermont. We know this not to be the case based on experiences of other states who have adopted this policy. For example, Illinois has a mandatory 72-hour waiting period law that does not contain an exception for gun shows. The state of Illinois is still host to several gun shows every month. Waiting periods are simply not incompatible with gun shows. If a gun show is set to conclude prior to the end of the waiting period, the seller could simply ship the firearm to a licensed dealer near the purchaser to finalize the sale. This is already a process that both licensed dealers and private sellers are familiar with at gun shows because it's the process that they follow for many out-of-state purchasers. Lastly, I would like to address the misrepresentation that New York courts have invalidated the state's extreme risk protection order law. In December of 2022, a trial court judge presided over a case involving a petition from an individual respondent where the judge opined that New York's ERPO law was unconstitutional. The state was not a party to the case, and the attorney general was not involved in the litigation. The decision has absolutely no binding effect on any other courts in New York. And indeed, all 20 ERPO laws, including New York's, remain in effect across the country, as they have since the first ERPO law was passed in Indiana nearly 2 decades ago in 2005. And we don't anticipate any state high courts will strike down any ERPO law. As with all court orders that impact individual liberties, ERPO laws contain robust due process protections. The process in ERPO laws is designed to ensure both public safety and due process rights of all parties involved. These laws establish clear and appropriately high standards for showings that must be made before a court issues an order, making clear the factors a court must consider and the burden the petitioner must meet before an order can be issued. These petitions must be sworn to under oath and contain specific factual allegations to support the claim that a person poses a significant danger to themselves or to others. These petitions can't be based on mere conjecture or speculation. There are safeguards in these laws to protect against abuse and punish those who seek orders maliciously. And anyone who knowingly files a false petition or files a petition with the intent to harass or annoy the respondent is subject to criminal prosecution. These laws also ensure that all parties have an opportunity to be heard on the merits of the petition. Only in the most serious cases where an ex parte order is necessary to prevent imminent harm can an order be issued before a full hearing. In Vermont, those orders can last only up to 14 days, at which point a final hearing must be held. No final order can be issued before the respondent has an opportunity to be heard and to present evidence as to why the order is not necessary. These laws give respondents opportunities to petition the court to terminate the final order after one. In short, the provisions of H.230 are well established and constitutional, as evidenced by the implementation of similar laws all across the country. Thank you for the opportunity to testify and lend support to your efforts to address the epidemic of firearm suicide in Vermont.
Well, questions? Go ahead, Angela.
Thank you very much for being here. And I know you may not have considered this before, but I was just wondering, well, maybe you've considered everything. I was wondering if you have any thoughts on the Sixth Amendment concerns that were just raised for us regarding the penalty section of the secure storage element.
What I can tell you is that they're very similar to what we see across the country. Graduated penalties starting low-level fine or a low-level criminal charge in most of the jurisdictions. There are 10 jurisdictions that that are written in just this way, where a penalty can be levied even if no harm or access has occurred, and that is appropriately a lower standard. And all of those laws have been in effect and enforceable for 30 plus years. Is that how long they've been? These laws in this iteration have been on the books. So yeah, they remain, that challenge hasn't come up to my knowledge, and certainly hasn't been sustained in any way or struck down any laws similar to this.
Thank you.
So we had some issues regarding vagueness with respect to the safe storage. For instance, under the control of the owner. I am sending some language that from other states, but would you suggest any particular language that would help with that?
Actually, you're close by in New England. Connecticut has described this a little bit in statute. A lot of statutes just use control because I think most gun owners also understand what control means. Like, that's one of the primary rules of responsible gun ownership, is to always be in control of your firearm, period. So there's sort of an understanding for people who use firearms as what control means. But Connecticut describes it a little further, and they say the person who carries the firearm on his or her person or within such close proximity that the person can readily retrieve or use the firearm as if the person were carrying the firearm on his or her person. So if you want to borrow some language that gives a little color or a little contour to what control or custody means, Connecticut has some good language that I think you might want to consider.
Great, I appreciate that. So also there's and maybe you don't have input on this one, the concept of displaying the firearm in a threatening manner. That may be a little more technical as far as what our laws, our offenses are. But any other states use similar language? And any challenges to that language that you know of?
Let me look. I can look through all of them and get back to you to see if I see that a lot. I think that this language was changed from the bill as originally filed. And I think the reasoning in the prior committee for changing it was the concern that mere usage of the firearm shouldn't constitute that level of a penalty. So if kids borrowed the firearm and were shooting bottles in the backyard, that wouldn't fall under it. So I think it had been changed in committee. I'm not 100% sure, but I think that was the thought. But in other statutes use access or use rather than necessarily this kind of criminalizing behavior. But I can pull and see if other laws use, other states use that particular formulation of threatening manner.
Well, let me ask you an actually related question. So are there other states that have language that would exempt if the child is using the firearm under the supervision of an adult or something along those lines?
Yeah, there are other states that have that, and in some states that wouldn't be unauthorized access, right? Because that
right.
Would be legally, right.
That would be one of the exceptions, because I'm increasingly thinking that I might float this idea. I'll float it now so people can put it in their mind, and we can also maybe get some more language from you that actually striking the fine not more than $100. Just I think that causes some issues, but we can get into that later and talk that out a little bit. But I'm thinking about actually in the subsection 2, striking everything after and uses it in the commission of a crime or displays it in a threatening manner. So if a child gains access to the firearm, that's when the 1-year misdemeanor would occur. And I assume that there's other states that do something like that. But then we'd want to have the exception, if they have access to the firearm under supervision. I'm thinking about that. I might get some input from the committee before I ask Eric to do something with that. And people our witnesses will have an opportunity to weigh in on that tomorrow or Thursday. So, but if it's possible, if you could just point exactly to, if to some state that does it along those lines, that we could look at their language, or if you could even send us that language, that would be super helpful.
I just was able to pull up, Maine has almost the same formulation and uses in a reckless or threatening manner. That's in Maine's statute, but I can look it through and see if I can get more. I think there might be 6 or 7 examples.
Right. Because, we're running into various issues, and this might actually help us get through those issues. Let me see if I had any other questions while I'm thinking of any other questions? I think that we're good. It looks like. I really appreciate your time and enjoy your vacation.
One quick question.
Oh, I guess we got delayed from your vacation by a little.
Sorry, you just mentioned a moment ago that Heller didn't invalidate firearm storage laws, and I was just trying to find the quote in Heller for that. Could you just point me maybe to the section? I can take a look at it later.
Or yeah, I'm sorry, I don't have the decision up here, but I have the I can get you the page.
You can also
number.
email it to us. It's fine. If you want to just email the page number, that's perfectly fine.
Yeah, let me do that. That's easier. Okay.
Thank you.
All right. I really appreciate it. Enjoy your trip. I understand it's not a vacation if you go with kids.
Thank you. Exactly. It's no vacations anymore. They're all trips, but I'm very excited, and thank you for fitting me in today.
All right. Thank you, Allison. I think we certainly have time to hear from Judge Zone as well, since we have him. So over to you, Judge Zone.
Well, good afternoon. Tom Zone, Chief Superior Judge. And I would note that Representative Dolan asked a question before about the law and was asking about courts are going to have to rule on things. And that is precisely why I will start out by saying, that's why I'm not wading into any of the questions you've just listened to answers on for the past several hours, because that is what's going to happen generally when you have litigation. The courts will decide it. And so it would be inappropriate, I think, for me to wade in on that. But what I would want to do is just touch base briefly on the ERPA section. And Representative Lalonde, you had floated some options for section 4052 about the venue or jurisdiction of where the action is filed. My suggestion would be that we leave it the way it currently is, not in the bill, but I would not put where the family or household members reside. I'm unaware of any issues that have arisen by virtue of the fact that it's where the respondent resides or the county where the events giving rise to the petition occur. It's less confusing. It has a predictability. It also, as Mr. Tebow testified, it provides a basis to know that, okay, the witnesses are going to be in this area. And it would, while on one level, I would acknowledge that it might be more convenient for the family member who lives in Bennington County to file it in their county. If the respondent lives in Franklin County and all the facts are up there, it should be in Franklin County, and we shouldn't start having something be transferred and venue changed. I'm unaware of any issues, so I would suggest you may want to leave it as it currently is.
Appreciate that. Thank you.
The issue that comes up that I had been thinking about a lot is the family or household member. That will be a policy decision by the legislature. And I believe out of the states that have ERPO laws, at least 13 of them allow the filings by family or household members. The impact of that is one that I think would be increasing the number of filings. At what level, I don't know. But I would suspect that the filings may be increased, because I would also suspect that the state's attorneys and attorney generals exercise appropriate discretion in moving forward. In other words, they don't pursue one that they don't believe is appropriate, and they will do an appropriate investigation to get facts. And I would agree with Mr. Tebow when he said that the family are the ones who would best know the facts. I would also note that law enforcement helps assess facts and gather facts, and the state's attorney is the one who applies those facts to the law. And so while it may be opening up the ability of family or household members to be able to file and broadening that, the real question is it necessary? Has that been a problem to have the state's attorneys have to file these in the past? And Is there any negative to it? It's certainly difficult to argue and assert that, well, the state's attorneys should have control from the inception when they themselves are saying they don't want it. But I can imagine circumstances where there may be a valid basis. And yes, while many family or household members will file after hours for relief from abuse orders on their own, this is an extreme risk protection order that brings with it significant issues that the minimal number of cases that are filed per year when compared to relief from abuse show that it is a situation that is heightened. That's why you've just spent all this time talking about these important issues. And so having a prosecutor who is the one that guides the case from the very beginning, I suggest gives you a better potential outcome. It minimizes the risk that a self-represented litigant might not properly understand what they needed to file and having a petition potentially denied. But that's a policy decision for the legislature. If the legislature chooses to go forward with family or household member, the term household member is extremely broad. It would include the two roommates from UVM 10 years before. And so you have to, I would caution you to hone that down and tie that down and maybe make it just family members, maybe or current household members, however you'd want to do that. But I think having it broad so that any past relationships can come back would be overly broad. There is an impact that would be felt by the judiciary. Currently, the way that an after hours ERPO works is the state's attorney contacts the judge directly, and the judge treats it like a search warrant and then would issue the ERPO. If the citizens, if a family or household member was going to do it, we then have to have a system where they go as they have to get the paperwork. The state's attorney wouldn't be preparing the paperwork as they do now and get all the documents together. They would have to go and treat it like a relief from abuse order, and we would have to set up a system that would be able to handle additional calls at night. So they would have to go through an after-hours system. My understanding is that if you look at the cost of the after-hours system, the expectation would be that it would cost, we would most likely need to add one more after-hours person, and the cost would be, and this is very rough, it could be higher, I'm told, it could be $20,000 to $30,000 as a budget when we look at having someone on call to deal with different calls for ERPOs. The other point that the state raises, that the state's attorneys talk about, is having it shifted over to the state's attorneys for the final hearing. If the legislature chooses to have family or household members file, I would support that, because the reasons indicated by the Department of State's attorneys in their written filing and in the testimony today amply establish why it's important to have someone with legal skills be able to pursue the case and meet that burden, which is a higher burden of a clear and convincing standard. And so I would support, if the legislature does expand who can file, that it should be done by the state's attorneys to make sure that it's done right. And it's done in a way that is consistent. Now, I would also suggest that there be language added that what happens if a litigant files it and the state's attorney determines that they don't believe they should go forward, even though there was a temporary order, because there's the state's attorney does a bit more investigation and believes the order may not have should not have gone forward by finding out facts that were inconsistent with what was represented. I think there has to be the ability of the state's attorneys to, or attorney general for that matter, to not pursue a case that they believe would be a violation of their ethical responsibility. If they, for instance, if they find out that there's information that's incorrect, that information was not put forth. But I would support the concept of them taking the cases over. Again, they're important cases, and we want to make sure they're done right. That's about all for comments. If there's any questions, I'd certainly be happy to address them. Except ones about weighing in on constitutionality.
We know you want to get this case eventually. Any questions? Angela?
Promise, it's just a process question. You mentioned, hi, Judge Zone. You mentioned that a family would have to go through an after-hour system, and it sounded like, if I heard correctly, you were saying this would have to be a separate system from the one that currently exists?
It would not have to be a separate system. We would have to change the system that currently exists in order to be able to address this. The workers now are people who are knowledgeable about relief from abuse orders. There would have to be additional training. There would also have to be additional individuals added to the after hours list to be on call at certain hours based upon the anticipated change. If it's during court hours, it would not go through after hours, and we would be able to address it during the normal court hours.
Okay. And out of curiosity, how do you anticipate the change? When you say the anticipated change, like, do you have a formula for guessing how many of these would be filed after hours?
I actually, while I was listening to the testimony, was reaching out to try to find out that information. And at this point, we don't have solid information. I understand that it can be for each individual who works on a weekend, the after hours worker, depending on their normal rate of pay, that it could be an additional $300 to $400 per weekend shift that they work. And so we were looking at it from that perspective, or at least I was. So I kind of extrapolated from there. If you look at it, there's also on-call pay that they would receive for standby. So the numbers I have used are extremely rough, if you will.
Thanks.
So if we pass this with this provision in here, we should be sending it to appropriations so you can ask for the extra 20K? Is that kind of what I'm hearing?
Or more. I was just, or more, but what I would do is have Terry Corsones and look at it from the financial side and to decide to figure out exactly what we think the real budget impact may be.
Okay.
But
you know
I wanted to give you that number because that was just the number that was kind of a rough number. It wasn't like it was, if it's $2,000 or $3,000, I hate to say it, but we can absorb that. And then Terry might not like me to say that, but I think she would say that to the little numbers like that we can work with. But when we start getting into the more adding the zeros, it gets more difficult.
So you know that most of this committee wanted you to ask for 2 additional judges, not 1.
Sold. We'll go with it.
That's, I think, was in our recommendation, if I'm not mistaken, down to the appropriations committee. So we're trying to cover you. So
we very much appreciate that. Thank you for that support. It is very, very helpful. Thank you.
Ella.
I think we did talk earlier. I think Mr. Tebow said in his testimony that there were about 20 ERPOs issued in 2022. Did you say that? Does anybody know how many of the temporary ERPOs?
There was the report. Our court administrator, Terry Corsones, did file her report.
Okay.
It said that in fiscal year 2022, there were 41 extreme risk protection decisions. There were 24 temporary orders granted.
Can you have Terry, or can you send that report to Panina so we can post that?
I can.
I appreciate it.
Thank you.
Any other questions for Judge Zoney? Joe.
Thank you, Judge. I asked a similar question, Mr. Tebow, about an hour ago or something. One thing I'm sort of trying to get my head around, if we continue with this family household language, is how a judge will sort of confront such a, whether it's after hours or not, such a filing in an ex parte manner. Because these, as I understand the ERPOs, they, as you said a few moments ago, they're very impactful. They're very important orders that can be issued, but they'd be done ex parte based on affidavit of, if it was to stay as is now, a former, someone you were in a relationship once a long time ago. And so, I worry this could be used in a way that could be actually against a person in a way, since we don't have that firewall of the state's attorney. And so I'm just sort of wondering, if a judge was to get, whether it's, regular course of business or after hours, such a filing and affidavit, in an ex parte manner, how would they sort of work through being able to determine whether or not for the preponderance was met based on that affidavit and make a decision to issue the temporary at that point?
When a judge looks at a filing such as a relief from abuse order, which we have similar filings now, the judge has to assess based upon the evidence that is before he or she. We don't have the crucible, if you will, of cross-examination. And in many ways, you have to accept what is there. If these facts are true, we then apply the law to those facts, and we would then issue an appropriate order. So it really, in many ways, is if it says if someone says, A, B, C, D happened, and it's under oath, judges are going to say A, B, C, D happened. You have nothing else telling you, and that's why, as you I think are touching on, having the state's attorney there as the intermediary is able to figure out what really has happened. Having the state police or other law enforcement do additional work sometimes will provide another level of review, if you will, before the judge sees it. Because again, the judge, if you get a call at 2 a.m. On a relief from abuse order, the worker reads you the affidavit over the phone. You're just hearing what one side says, and you have to base your decision based upon that.
Thanks. And what is the impact on the defendant of a temporary RFA versus a temporary ERPO? Are there more significant things that occur to you in an ERPO, or are they basically sort of the same?
Well, the ERPO would take away someone's firearms. A relief from abuse order under the law can currently have someone removed from their residence. It can have restrictions on contact. It also can have provisions that also have firearms have to be relinquished. So there are significant impacts from a relief from abuse order also.
Great, thank you.
Any other questions? I don't see any other questions. Thank you very much again, Judge Zone. And since we have Austin Davis here, I understand that his testimony is going to be short, so we may as well, since you're here, please identify yourself for the record and
Good afternoon. Thank you so much for reaching out with this invitation to lend our voice to a conversation which typically we wouldn't find ourselves in. For the record, my name is Austin Davis. I am the Director of Government Affairs with the Lake Champlain Chamber. We are a nonprofit business association representing the businesses of Northwest Vermont. We got a knack for nurturing our community by fostering economic opportunity for all Vermonters and serving as a resource for our business community. Our work is typically best summed up as seeking economic opportunity for all, celebrating business ownership and entrepreneurship, promoting a robust, diversified visitor economy, cultivating community leadership, and nurturing emerging talent. Knowing about the Chamber of Commerce, which you all likely have a regional Chamber of Commerce in your neck of the woods, and hearing the above mission, it probably seems strange to have a chamber lobbyist in the chair today on a piece of legislation such as this. We neither have a history of weighing in to these types of conversations regarding firearms, nor do we have a deep bench of expertise on the matter. However, what we do have is a membership that's deeply concerned with a recent rash of gun violence in our community and an imperative to do something to curb that disturbing trend. So early this fall, the Lake Champlain Chamber pulled together an ad hoc public safety committee of our board of directors to put forth policy recommendations for a greater public safety in our region. The end work product was very similar, actually, to what was put forth by Burlington's mayor, Earl Weinberger. So our board actually connected with the mayor, discussed it further with him, and decided to actually endorse his public safety proposals as the chamber policy positions in our February board meeting. Among the items in the 16-point plan is a component around safe storage, which is what brings me here today. Within the city of Burlington, 6 of the last 17 firearms seized by Burlington Police Department in the course of investigations in 2022 were found to have been stolen firearms. Safe storage is not a new policy discussion for our city or region. In 2014, 61% of Burlington residents voted to send a charter change to this legislature that would have required safe storage within city limits. The language provided by the mayor and also endorsed by our board also has a reporting requirement for lost and stolen firearms. Had this legislature allowed the Burlington the ability to act on these charter changes that voters had overwhelmingly supported, an initiative for safe storage potentially could have prevented some of the Burlington's most disturbing incidents and saved lives. While we understand that this bill is focused more acutely on suicide prevention, another policy area of just generally public safety is incredibly important to us, and we believe this provision can enact well to that. Regulations such as background checks, which I saw today, President Biden is actually expanding greatly, and age limits are easily sidestepped if firearms can be easily available to individuals if presented with unsecure firearms. While we understand that Vermont has a long, proud history of Second Amendment rights, with a thriving outdoor community and industry, with many of these users using firearms responsibly and locking them up, we don't see it as an unreasonable regulatory burden to ask these individuals to ensure that their safe storage of their firearm can keep their community and their families safe, the same way that many other New England states do. So admittedly, as I said, this is not typically an area that we weigh into. These are unique extenuating circumstances, and we felt the imperative to do so. I'm happy to take any questions, though I can't speak too much to the subject matter.
Any questions? Yeah, Barbara.
So thank you for testifying and reminding us that the charter change that the Burlington population approved by a wide margin never got out of committee. So I appreciate you wading into this area because it is interfering with business and civil, or fear at least, of people in Burlington. So thank you.
So there wasn't a question.
No, I'm sorry. There was not a question. I could ask you a really tech. Do you think that this would be an unconstitutional bill?
Perfect.
I was amazed to tune in earlier and hear gunpowder storage legislation of 1853 cited. Certainly outside my bailiwick.
I think we're all set with that. Thank you very much.
Well, thank you for your invitation, Todd.
Yeah, no, thank you. Thank you very much for, oh, I'm sorry. You had a question. Ken had a question. I was just about to get in huge trouble.
Pretty much. Do you, any of your people that you represent, do they have any concerns about the lack of police that is, the police force was taken away, 2-3 years ago there, and now they're building that back? Does that enter anybody's mind?
Certainly. So the plan we endorse is a 16-point plan with subpoints to it. Some of that involves officer recruitment and retention. We're working with the city of Burlington on those matters. They range from smaller items just around large items such as the question 7 that was on the ballot that we stood in opposition to with Mayor Murrow Weinberger, that would have created a citizen oversight board that would have had expansive control and been unprecedented. There's also items such as a non-residential academy for police in the state. One thing that we've seen certainly makes community policing difficult in the city is that many of the individuals who could potentially step up and take part in the police force are in a life circumstance that it's hard for them to leave their family for an extended period of time to a residential academy to learn the essential skills to be a police officer. There's conversations around how can we bridge that gap? How can we do something that allows an individual to have more on-the-job training while also getting them the outside exposure they need? So that's certainly a component that we're very concerned about in Burlington. And it's interfering with commerce in many ways. Public safety in general is interfering in commerce, but also certain events require minimum staffing levels from police to safely close down streets and things of that nature.
I was under the impression that I'm not a Chittenden resident, but I was under the impression that city council Weinberger wanted wanted a police force, but city council didn't, and now they reversed course. Now it's time to rebuild the police department.
Well, as the saying always goes in this building, elections have consequences, but legislating also has consequences that are seen in elections. And we certainly had an interesting town meeting day in Burlington that will result in some change in direction potentially.
So do you think there's, you don't mind if I keep asking
Yeah,
questions?
no, I do. I mean, this is
You do?
way far away from this bill.
You want to bring witnesses in here, right? We hear all day from certain people. It's like, come on.
If you can tie it to what the bill is, I'm happy to yeah.
Is this bill going to curb what I see as a drug problem up there? Is that going to make households more safe with this safe storage?
I think that's an all of the above conversation. There's no one item, and that's why there's such an expansive plan that we've laid out and stood with the mayor on that can get at a number of issues. Certainly substance misuse disorder and mental health is a component of that. There's also a serious need for better communication between our police force and our communities. There's trust that needs to be rebuilt. There is housing that needs to be built in our cities, and basic quality of life changes. I'm happy to send that to you.
Did you say anything about drugs?
I think that goes into mental health and substance misuse disorder. Yeah.
Thank you.
Thank you for connecting it. Tom?
Ken brought up something that's sort of been on my mind a little bit throughout the whole day, and it's good that there's some other lawyers in the room on both sides. We need more police officers so that we can enforce these laws, correct? But the thing that in my mind is, how are we going to enforce particularly the storage law? The storage law, to me, when I look at it from my perspective, is going to be something that's going to be investigated and dealt with as incident. It's not going to, there's no way for me to find out who's storing their guns correctly until there's an accident. So that being said, I'm not sure how much is really going to help, because people will become complacent and not necessarily store maybe the way they should, or just ignore it altogether. I'm afraid guns will get stolen and not reported stolen because of the law, because they don't want to introduce themselves into being in trouble.
Well, I certainly think there needs to be an educational component of this. And, I think this is to some extent, a larger conversation around what is the purposes of our laws and policing. Is it strictly enforcement, or is there a preventative component to that as well? Certainly knowing if there's consequences to not properly storing a firearm can go a long way. I certainly think that there's responsible gun owners in this state, if educated, if aware, might spend, the relatively small amount of money to safely secure a firearm when you look at the potential downside of a fine.
Well, virtually every new firearm is sold with a lock these days.
And that's fantastic. I think that there's a lot of, I've grown up in a household with firearms, certainly not necessarily secure. And there's a generational component to this. There's also just a complacency component to this. I mean, one of the firearms, as I understand it, that was used in a murder incident was left in the front seat of a vehicle. I'm aware of it. And it was very easy for someone to break into that vehicle, take the weapon. You might think twice about that. Maybe if I'd hope that the thought that your vehicle being broken into and that firearm being stolen, the consequence of it being used in a violent incident would be persuade a person enough to lock that up safely. If not, maybe a fine will.
That, and if crime was being dealt with a little bit better, maybe that would help too.
All the above.
All right, thank you very much. And just before we break, I just wanted to run through and get some input on a couple things, because I am going to have Eric working on a revision, a revised draft for us to consider tomorrow. And here's kind of what I have, and people will chime in. Definitely need to have a better definition of control. And I have sent him the language from Connecticut, from Connecticut's law. Still need to deal with the penalties section. I don't agree that there's a Sixth Amendment issue there. We can get some more input from Eric a little later on that. But I do understand the concern about the threatening manner issue. I also actually wanted to even add something there, but maybe there's the other approach that I proposed, which is just if they gain access to the firearm, that's when the penalty is imposed. And I don't know if folks have an opinion on that one, Joe?
It's a process question / opinion more than I feel that I, at least, am at the point where I'm really ready to talk about this bill. I don't know the answer to your question yet. Like, it's something I would want to think about and bounce off in the committee. The private person I'm most interested from hearing from again is legislative counsel as we have that conversation, because it's, I think we've heard from a lot of people from a lot of sides, and each person has a bias that they are likely paid to have. And that's fine. We expect that in the system with lobbyists and everything like that. But I feel I've heard every side of this so far, and I've also heard one side claim one thing is true and another side claim another thing is true. And I look at it myself and I find it's a third way. But anyway, point being that I'd love to have a conversation about this bill at this point, and then maybe go from that conversation into what edits are necessary, because that's where I am.
So I would normally love to follow that, but since we have another bill, a couple of bills we have to get out, it'll be an iterative process. I think the conversation can be based on some of the changes that we've already heard. Because, for instance, you've asked several times appropriately, absolutely, about the household. And I'm going to ask Eric to narrow that definition. So we don't really need to, I don't think we need to talk about that. I've heard a lot already from the testimony, from your questions, from other people's questions, to know where some of the trouble spots are. And I'm going to take a run at that. And definitely I'd rather have a conversation on that than what we already know is not going to be what the final bill is. And if there's more changes beyond what, that I've heard, we can do it that way. But otherwise, yeah, it's just that we have a pretty compressed time. So that's why I was just we don't even have to have, people don't even have to comment on me right now. I could just suggest, these are the things that I'm going to put into this next revised draft, and we can decide whether we like those or not, just to keep the ball moving.
Yeah, that works.
So, but yeah, we'll definitely, tomorrow afternoon, we have a number of witnesses, but we can start with conversation, or we can just hear from the witnesses. It should be much narrower because it's just going to be on these few changes that I'm going to suggest. And we'll definitely have lots of conversation after floor tomorrow. Maybe I'll leave that part, but I wouldn't mind seeing what the language would look like if I was going to change it, where we got rid of just the fine, and we did if somebody accesses the firearm, and then we'll have the exception or exemption, I should say, exceptions under the exceptions section, if the child has access to the firearm under supervision or something along those lines. Hopefully we'll get that language from Allison. So if they're out shooting bottles or whatever, you don't want the kid out there shooting bottles. In any event, I'm going to suggest changing the shall to may on page 4, line 2. I'm going to suggest the modification to household members, to narrow that to the present household members. I think the right decision on the jurisdiction venue is to strike family or household member. That's still, all these things are up for discussion.
What does present mean? And I really can't stay past my limit.
Temporarily, that they live with right now, or they are dating right now, current, is what I mean by that. So the final thing that we have only had some tested, but we had some testimony on this, is my plan is to float some language that would exempt gun shows, would define gun shows first, and then would exempt them from the 72-hour waiting period until July 1st of 2024. I will be on the record asking, I could even ask right now, but I'll reiterate that I want a bill to start drafting for consideration at the beginning of next year, hopefully, on some means of having a firearm owner, have a firearm owner ID or something that specifies this is a person who has a firearm, should not have to wait 72 hours. Either in the gun shows, right now, Florida has a 72-hour waiting period. But for gun shows, they exempt somebody who has a concealed carry permit. I'm not suggesting we're going all the way to a concealed carry permit, but some way to identify that somebody is a current firearm owner. So that language will be in the revision as well. Is there anything that's jumping out at somebody else right now? I know I don't want to but these are ones that I've kind of been hearing, as well as the changes that we heard from state's attorney with respect to the ERPO law.
First of all, I wouldn't exempt gun shows, but that's just me. Or people who already own guns. But on page 5, I have a note about something that I think Tom had flagged in the language of that warning. It was like changing it. Do you remember this, Tom? Line 3, it was like premises under their control if a child or person, and I have or a child. It was like person or a child. There was something where you brought something up, Tom, if I remember.
Was it having to do with, I know what you're talking about. The definition of a child being 18 or under?
No.
My note here is we want.
I have that highlighted because there's no child gun law in the state of Vermont.
Right, so you wanted to make sure that child wasn't part of a person prohibited from purchasing or possessing?
Oh, it was the reverse one.
Yeah, reverse them. So it was, the concern was that.
Right.
As if a child or person prohibited from possessing, it should be a person prohibited from purchasing or possessing firearms.
Comma, or a child.
Yeah.
Yes, thank you.
Couldn't quite understand my own note, but.
Did you hear that, Eric? On page 5, line 3, the child should go after.
Yeah, I got it. Yes, exactly.
Yeah, I think
I recall that from the last time we talked about it as well.
Right. So, and I understand where you are, Angela, with the other thing, but this is for discussion.
Yes, I will keep
Ellen,
listening.
See, I have 2 other things that I thought seemed like things we wanted to address. The one on page 4 about the warning signs. We talked about the fact that many places don't have a physical location for a gun shop, get guns. So we discussed do we want to add a provision that if you don't have a physical retail space, that then there's a handout instead of a posted sign? That came up really early on and seemed logical. I don't know what portion of gun sales happen in that format, but if we really want to educate people, we should make sure they get the message. And then, especially if there are penalties, I think we should be making sure we're educating people. And then page 8, we talked about needing to address, in terms of the 72 hours after the completion of a background check, need to address when the 72 hours start so it doesn't, that it overlaps and doesn't add to the 7-day period.
Right. I think Eric probably has that from before, I assume.
Right.
Yeah. Okay. So, all right. So the FFL one, we'll have to ponder that one a little bit more. I'm not sure that there's a quick language change there necessarily. I've been thinking about that as well. But when I read this again, it's like display a sign containing this information anywhere the sales or transfers occur. In past years, we've gotten testimony that gun club could have an FFL there, and so if they have the FFL there set up, they could have the document at the table, or and I've heard about the kitchen table FFLs. You have it on the table, so it may not be necessary.
That's fine.
It just may be a little complicated to try to define that.
That's fine. I just wanted to reiterate.
Thank you for flagging that. Tom,
is secure storage again. As far as that goes, are we meaning residents or any place? You brought up gun club, which is,
Well, I guess it's, is that a premise? where-
There's others. I'm hesitant to even bring it up.
Well, no, is that, I mean, right now it's premises, which could be any place where it's
Correct.
known that a child or prohibited person is likely to gain access to the firearm.
Any public place, there's plenty of public places where they can walk in and access that.
That's premise. Yeah, that I wouldn't call a premise a public place. Eric? Any,
They're open.
It would have to be someplace that's under, the person's custody or control. In other words, they're the owner, they're the landlord, they're the person who in some way controls the premises. It's sort of the nexus between the person and the property itself. So I didn't quite follow the fact pattern necessarily, but I think you'd have to have that connection, not just any building that a person happens to be in, for example.
Their workplace. If they're the.
I think there should
If it's your
be
business.
after control, and it makes it make more sense. So a person shall not store or keep a firearm within any premises that are in the person's custody or control, comma, if the person knows or reasonably should know. And so like, a gun club wouldn't be under the custody control because it's probably the person, I would imagine this would extend to whoever the, I don't know what the person's title would be, but like the director of the gun club, because that would be a premises under that person's, custody and control. And so they would have to make sure things are locked up. But that's my reading of the thing there, talking about individuals.
Well, I'm the one in custody and control of my gun when I go to a gun club, and I put it in the rack and I turn around and leave it. So it's everybody that's there.
Yeah. I think the issue is that because it says premises. And so we're sort of mixing a little bit because we talk about custody of control of the gun or custody control of the premises. So yeah, I see that as part of the premises being under custody control, but I understand what you're saying here.
Mm-hmm.
Yeah, I think that's right. It's intended to modify premises. The custody and control in that context.
okay.
So it wouldn't be just any firearm. It would have to be the person who has custody or control over the premises, not the firearm.
So, yeah, we just need to do the grammar there to make it very clear that person's custody or control is related to premises and not to firearm. It may be a little bit ambiguous. I don't know if you need to drop a comma after firearm and then after control to make that clear.
I mean, it does say premises that are.
Yeah, firearm within any premises that are under the person's, you can
I think
kind of,
it's a little ambiguous.
yeah, you can read that the within and the that are modified firearm.
Couple commas will fix it.
I love commas.
I hate too many commas though.
You're an open comma person. I'm a closed comma person.
With the conversation of commas before Ken's head explodes, we're going to adjourn until tomorrow at 9:00. We're taking up H-171, which I don't know if that's changed on the, that's the bill we're doing a drive-by for human services, and we're going to try to wrap that up tomorrow morning. On the committee page, there is a new version of that, and our suggested changes are in purple, pink, chartreuse. I don't know exactly how to label that color. I should. And then we're going to do the Dram Shop Act.